Good day, CrimeTalk aficionados. It is Saturday, March 26th. What does that mean? That's right. It is time for your weekly recap of the top stories throughout the week here on CrimeTalk, all located in one convenient location. That's right. You're welcome. First, let's open the record. Gannon Stout. On March 17th in 2020, workers at a Florida Department of Transportation found a suitcase under a bridge near Pensacola, Florida, and unfortunately inside of that suitcase was the body of 11-year-old Gannon Stout. Now, Gannon was first reported missing on January 27th of 2020, and before his body could even be found, Gannon's stepmother, Letitia Stout, was taken into custody for his death on March 2nd of 2020. Letitia faces a slew of charges for his death, including first-degree murder, which, if found guilty, carries a mandatory life sentence without the possibility of parole. Now, Stout has had hearings scheduled for as recently as last Thursday on the 2-year anniversary of finding the boy's young body, but the hearing was rescheduled for later in this week. In February, Letitia Stout pled not guilty by reason of insanity, which caused more delays in her trial. Now, Letitia sits in the El Paso County Jail in Colorado, awaiting a trial date for the death of Gannon Stout. First, there was another hearing in the Chad Daybell matter, and it was in regards to the motion to dismiss, basically for grand jury misconduct. Okay? Now, these motions have not been made accessible to the public because it does involve grand jury proceedings, and they're supposed to be in secret. So let's do a quick background. What is a grand jury? Well, normally, most people can be charged via a complaint and information. That's where the district attorney goes to the judge and says, "Judge, here's an affidavit for probable cause. Please find it." Judge signs off on it, and then you can go to a preliminary hearing. Or you can be indicted by grand jury. If you're indicted in federal court, you have a constitutional right to a grand jury, but states, not so much. But they can be used for special cases. They can be used as an investigative body, and it is a grand jury in comparison to a petite jury, which is 12 or less. A grand jury is 12 or more. Usually a grand jury is 15 to 25 people who will hear evidence in a case, and they will decide if there's in fact probable cause. Well, when they seat a grand jury, the government seats a grand jury, there is the judge that presides over those proceedings at the initial appearance of all the jurors to make sure that they're fair and impartial and that they can actually hear the cases. And if they think there's something they can't be fair and impartial for, they're supposed to let everybody know, say, "Hey, I can't be on this one. I'm out." Okay? But once the grand jurors are seated, the judge says, "Fine, go forth." The judge is no longer there. It's basically run by the prosecutor. And so let's say, for example, in the federal system, the grand jury meets a couple of times a month. Well, you may have multiple prosecutors that literally get 10 minutes to present probable cause for their particular case. They submit the paperwork, the grand jurors sign it, boom, next case. Okay? In the case like Lori Vallow and Chad Daybell, obviously a little more time was spent on it. And those proceedings are recorded. The votes of the grand jurors are generally secretive, and when somebody gets indicted, they're entitled to the grand jury transcripts, but normally they are covered by a protective order, which means you can't disseminate the grand jury transcripts to anyone other than basically, well, the attorneys and the defense team. The client usually can't even get them or get a copy for themselves. They can read them, but they can't get a copy of them. Now, you can always challenge the grand jury proceedings. You can file motions saying, "Hey, I want a list of everybody, everything that took place." And then you have specific arguments. You can say, "Hey, the entire grand jury is completely void because it was conducted improperly," or you can challenge specific grand jurors. How do you challenge specific grand jurors? Basically, it's because they say something in the grand jury which makes you question whether they are being fair and impartial. Now, it is the job of the prosecutor handling the case saying, "Okay, that's your question, but understand the defendant is given presumption of innocence. You can't consider all these other bad acts." It's kind of like court, but it's very much relaxed. You've heard the saying, "You can indict a ham sandwich," because that's really what it means. The prosecutor says you're going to find probable cause, you found probable cause. The paperwork's all filled out. The grand jurors simply raise their hand and say probable cause. And 99% of the time, it is a no-brainer just like that. Well, here we have to read between the lines a little bit based upon the arguments that were made at the hearing. Now, the defense in this case, Chad Daybell, through his attorney, filed apparently a 55-page brief outlining why there were irregularities in the grand jury proceedings, and therefore a motion to dismiss the entire case should be granted. Now, the prosecutor, although they've had this brief for several weeks, basically couldn't meet the deadline to have their brief submitted, and although they made an oral argument today, they asked for additional time, and the court granted additional time up to April 6th to file their brief because they wanted to be able to cite to specific instances in the transcript, which they cannot do in open court, which is today, because of limitations put on by the court's order regarding the grand jury secrecy. The defense has then until April 20th to file a reply brief. So we are already at the end of April before we'll probably get any decision on this. So the argument that was made by the defense, and we got most of this through the rebuttal argument by the defense because he really stood on his motion that he had filed, basically saying that there was fairness and impartiality. There was not fairness and impartiality in this proceedings. The gist of the defense argument was that there was no fairness and impartiality of the proceedings. And therefore, he's asking for the court to throw out the grand jury indictment. And apparently some specific instances of this unfairness or lack of impartiality was cited in his motion, which comes from the transcripts, which we don't have a copy of. Now, interesting enough, the argument by the prosecutor was somewhat interesting in my regard. Now, first, when Miss Blake makes her argument, she sounds like she's a first-year law student that feels like she has to cover every point of law. Like, the court's going to get your brief, cut to the chase. Let me give you the cut to the chase version of her argument. Judge, everything was fair, but if it wasn't fair and there may be a couple of instances of misconduct or impermissible prosecutorial misconduct, well, that's okay, because even if a couple of grand jurors should have been disqualified, we still had at least 12, and that's probably good enough under the rules. If there was prosecutorial misconduct, maybe by allowing in information that was in fact impermissible, it really doesn't matter because it was only a little bit of impermissible evidence, and therefore it's okay. Once again, no harm, no foul. The prosecutor also alluded to, based upon some of the cases that she was citing to, that there's an allegation that there was some sort of relationship between a juror and one of the parties involved, i.e. prosecutors, or a witness in the case that maybe was disclosed or was not, but maybe they shouldn't have been involved. The district attorney, Ms. Blake, spent a lot of time arguing on that point, which makes me think that, small town, everybody knows everybody. Maybe this just wasn't the right grand jury for this particular individual, which kind of goes back to my point that we've made on lots of other cases regarding juror misconduct is, listen, let's get it right the first time so that you don't have to do it again, okay? Now, also, there was an argument about incomplete records, basically the recording in the grand jury proceeding. These hearings are usually transcribed or tape recorded, and when somebody stops and enters the room, they let everybody know, so-and-so's entered the room, we still have a quorum, something to that effect, and that there are no unauthorized people in the quorum. Now, apparently, Mr. Pryor wants an explanation as to why the recording or proceedings were not properly recorded, or at least not turned over to him. The government's argument is, hey, we can basically do what we want. We don't have to tell you what we did. And if the proceedings were, stopped, we don't really need to explain that to you, bottom line. So to recap, basically, everything was run fine. But if there was a problem, it's no big deal because we had enough jurors. We can do what we want. And even if you think that the motion to dismiss should be granted, hey, guess what? It really doesn't prevent us from refiling. Yes, we understand that it's a death penalty case and that the defendant is basically entitled to super due process. But we didn't give him super due process, but it doesn't mean even if you dismissed, we could still refile. So don't waste your time, Judge, by granting the motion to dismiss, because we'll just come back and do it again anyway. But I think the bigger point is everybody in this case knew this was going to be a big case. It was going to be watched, it was going to be scrutinized, and that everything was going to be litigated. Why do prosecutors try to cut corners? Just do it the right way. Give him the due process that he deserves. You may not like Chad Daybell, but guess what? He's still entitled to that due process. And at the end of the hearing, the court did grant that the names of the grand jurors be provided to the defense so that there can be individual challenges made to those grand jurors. Makes sense, fundamental fairness. The government wanted to let everybody know, hey, we're prohibited from turning this over pursuant to the rules relating to grand juries. It's not that we didn't want to, we just needed a court order to do so. It makes you also wonder why Mr. Pryor hadn't turned it over beforehand. But I can tell you, if there's an issue in a grand jury, even the release of the grand jury transcripts, usually the prosecutors file those motions to turn that information over early on in the proceedings. I just don't understand why the prosecution just doesn't seem to be able to get their act together. They had a year on this case before they even indicted. We are now a year past indictment, and they're still running around like they're chickens like a chicken with their heads cut off. Still trying to get organized. Listen, you knew when this hearing was. You knew the defense filed their brief in a timely manner. In fact, a day earlier than the deadline, and you couldn't be prepared to have your brief ready for the court. It's called mission accomplishment. It's called evenings and weekends to get that done and not just say, oh, well, Judge, we'll get it to you when we've had time to do it. Blows my mind, but I think that's the world that we're in these days. I once had a judge who thanked me for filing a brief on time, and I was like, well, you set a deadline. Why wouldn't I have done the deadline? She said, well, you'd be surprised the excuses that people come up with. So hopefully that explains in quick layman's terms what the issues are in the defense motion to dismiss as it relates to the grand juror alleged misconduct. We'll wait and see what the court does, but it'll probably be at least another month until we get a ruling on that motion. Just like everything else, no one's ever prepared on this case, and everything gets delayed. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked. Next on the docket, an update on Lauren Pazienza. Well, the parents of the 26-year-old New York event planner who allegedly shoved an elderly vocal coach to her death earlier this month may also face criminal charges after they allegedly helped her hide out at their Long Island home for about 2 weeks. Now, Lauren Pazienza was charged with 1 count of first-degree manslaughter and 2 counts of second-degree assault after she allegedly pushed Barbara Gustern, 87, to the ground in New York City on March 10th. Now her parents, Daniel, owner of a prosperous cesspool, I guess it's like a septic tank company on Long Island, and Caroline may face charges if the prosecution can prove they helped Pazienza hide from the police. Now, prosecutors said that on Monday, the New York PD detective visited the parents' Long Island home after receiving a tip that Pazienza was hiding out there, but that her father claimed that she was not at home and did not have consent to search the property, which is his absolute right to do, not to let them search the property, I might add. But if he did lie to him, that could be a problem. I'm not sure how they're going to find that out unless somebody confesses. Anyway, Miss Pazienza then surrendered to police early on Tuesday, and she is being held at the Rikers Island on a $500,000 cash-only bond and faces up to 25 years in prison. Just saying, ladies and gentlemen, how many times have I said, everyone's like, oh, I hate criminal defense attorneys. That'll never happen to me. Do you think the Pazienzas ever thought that this would happen to them or their daughter? You never know. That's why you always need to have your local, lovable criminal defense attorney ready and nearby. Just saying. Now, it's not unprecedented for parents to face consequences for allegedly trying to hide their fugitive children. As you may recall, the family of Gabby Petito, who was murdered by her then boyfriend, Brian Laundrie, they are suing civilly his parents, saying that the couple knew about the Petito's death and still tried to help their son escape the country. Now, as you may recall, when he departed, there were no criminal charges yet pending. So I think that's going to be a tough sell. I get the Petitos harmed, they're hurt, but at a certain point, you need to accept things and move on. I don't think that suit is going to go anywhere, just like I don't think the Pazienza's parents are going to be charged either. Thanks for watching. We'll see you next time. Enjoy.